We have witnessed a spate of withdrawal of cases facing various suspects, and some of whom have been nominated for appointment as cabinet secretaries. The profile of the suspects invites significant public interest as to the motive of the discontinuation of the cases, and further poses serious credibility concerns in the investigative capacity of our institutions. We are therefore alarmed by the recent decisions by the DPP, as they point to either two very disturbing scenarios. One, that the prosecutions were mounted for ulterior purposes whose end have been achieved or overtaken by events, or two, that the DPP has withdrawn the cases to aid an ulterior motive. The Director of Public Prosecution therefore owes the country an explanation as to the reason informing the discontinuation of cases. If the cases are being withdrawn for lack of evidence to sustain the charges, the DPP must take responsibility and explain how the decision to charge was arrived at in the first instance. We all recall that some of those suspects were arrested in somewhat dramatic situations, with media press releases as to the reasons for their arrest and arraignment in court. However, the discontinuation of charges have been done silently and without any press release from the DPP. The Law Society is also aware of the frosty relationships between the former Director of Criminal Investigations and the DPP, as well as the sustained efforts by the DCI to prosecute cases without the consent of the DPP. The Society therefore calls on the DPP to publicly reveal the reasons for the discontinuation of the cases if the public are to restore confidence in the office of the Director of Public Prosecutions.